Hello everybody, it's Rick. It is June the 26th, 2024. Yes, I know, it's been over 8 months. Excuse me. And I apologize, I've been busy, trust me, and this takes time to put videos together, and I just didn't want to do any video. I always try to post videos with different information. I've been studying, I've been reading, I've been helping people with paperwork, personally helping them, fighting summonses. So, these things take time. I try to do it the right way. And I really do try to put together the best paperwork I can. I'm constantly updating my paperwork, deleting paperwork, so on and so forth. Okay, so if you want to reach me, you can contact me. Understand that I don't always respond. Always check your spam folder. I can't tell you how many times people find my response in the spam folder. Okay, so if you're interested in my paperwork, my affidavits, send them to these email addresses here. Okay, because sometimes I can't tell you how many times I found people reaching out to me, and I find it in the junk folder, and I can't explain why this happens. Anyway, so what we're going to talk about today is here are some essential facts to keep in mind to help you navigate the child support court process and minimize mistakes. Again, I get emails from people who have my paperwork, and a lot of them make the same mistakes. They go in there and they try and speak, and then they get spoken over. There's virtual hearings. I would stay away from if you can, because all they got to do is press a button and mute you. Okay? I mean, that's not cool. I mean, it's really easy for them. When you're there physically, it's not that easy for them to shut you up, which is, I suspect, why they're doing it. So if you can avoid doing a virtual, I mean, really, you're virtual. You're not physically there. Okay? So I would refrain from that. If you have to go to court, you would rather be physically there. Your whole body is evidence that you're alive. It's evidence that you're there. It's evidence that you're not a legal fiction. It's evidence you're not an artificial person. Okay? Legal fictions, artificial persons. Your nom de gore, which is your all capital name, only exists on paper. You, flesh and blood you exist in this place called the real world. And the courts do not have jurisdiction over a man or a woman, which is why they switch you over. They represent you as an artificial person, a statutory person. And when you are a statutory person, you have statutory obligations. Okay, so real quickly, as you can see here, a statutory obligation is an obligation whether to pay money, perform certain acts, or discharge duties that is created by or arises out of a statute. So when they presume that you're an obligor, a statutory obligor, you have to abide by all the duties that they place on you. Okay? So this is all based on a presumption. And you want to avoid that. So you do that by declaring that you are not a statutory obligor, a statutory person. Okay, here's something else to look at. All right. Many of you out there that are unmarried, you have what's called an moral obligation, a duty that is based only on one's conscience and is not legally enforceable. Did you hear that? It's not legally enforceable. Okay, that means that they cannot enforce, it's not actionable in a court. That means that the petitioner or plaintiff, usually the mother or father in some instances, or even the agencies that step in as a plaintiff for the mother or father, they have no proof, unless they have actual proof of your signature on a contract saying, I so-and-so agree to pay you X amount of dollars, twice a month, 4 times a month, monthly. There's no contract. There's nothing to move forward with. It's not actionable. And right here's the definition. Also a natural obligation. So I combine moral and natural obligations together. Okay, natural obligation. You have a natural obligation because you're a father. Stay away from parent. You're a father and you have offspring. Child is a statutory definition. Okay, that's how they get away with making you pay child support till they're 21 years old, because they use a definition of a child in the Uniform Interstate Family Support Act, which every state has. Okay, they rely on these definitions. So again, civil law, moral duty that is not enforceable by judicial action, and we can include administrative as well. So that's a defense. So if you're dealing with a paternity issue, there is a defense. Okay, so again, here are some essential facts to keep in mind to help you navigate the child support court process and minimize mistake. Okay, so if you've been summoned to court, it's important to know that you're presumed to understand the law. Therefore, it's crucial to be aware that parties involved may use, not may, they probably will use trickery or deception, which means they are allowed to lie to you. Okay? Which is why you should not answer questions or give information. There's other reasons for that as well, and I'll get to it. Understand that you have the right to privacy. You have to understand by you doing certain things, applying for Social Security, but many of us applied for Social Security when we were children. Our parents did it. So technically, we did not express our consent. So we weren't really a party to that action, but that's another issue. Okay. But as a living, breathing man or woman, you have a right to privacy. You have a constitutional right to privacy, Bill of Rights, the Fourth Amendment. You have a right to privacy, which is why they need a warrant. Okay, and you need the Fifth Amendment. Okay, so you're allowed to withhold your private information. This is why they always are telling you, well, provide your driver's license, your proof of income. They want all of your information. You don't have to give it. Okay, just say I refuse at this time. I'm afraid that if I provide my private information, that I will imply consent, which is what they're looking for. Also, when you answer questions, you're implying consent, that the court has authority. Okay, so it's always best to respond in writing with an affidavit to make a conditional acceptance. This method not only ensures you are prepared, but also provides a clear record of your response. Send the affidavit by USPS registered mail receipt. The receipt will be your proof that they were served. Okay? And you don't got to deal with the nonsense at the clerk's office. They pull all of these scams. So you forget about it. I can't tell you how many emails I received with that nonsense. They won't, Rick, they won't accept the paperwork. Of course they're not going to accept the paperwork. Okay, so you want to serve it to them. You're going to serve it by USPS registered, not certified, USPS registered mail receipt. Okay. Also, you're going to respond in writing with the conditional acceptance, that the petitioner, plaintiff, actor, same thing, has the burden of proof, and you expect to see the evidence that proves the claims made on the day of. Okay, now, I cannot tell you not to go. Okay, they threaten you, but if you do go, you're there not voluntarily, because I've seen all these summonses, and they all imply some type of a threat. Suspension of your license, default judgment, contempt, all of these things. Okay? So, to me, that's coercion. You're being coerced. You're under duress. Okay? Always, and I'm gonna let you read the rest. Okay? Let me get to the next slide. Okay? So, declare in writing that you are a private living man, woman, endowed with rights by your Creator. Okay? And I'll let you go. And also understand this. Waivers of constitutional rights not only must be voluntary, they must be knowingly intelligent acts done with sufficient awareness. Now, if you're not aware of the relevant circumstances and consequences, you cannot make a judgment. You cannot be making a voluntary judgment to waive your constitutional rights. Okay? So it all comes down to status. All right. So here I'm touching on your legal status, which by declaring yourself a private living man, woman, endowed with rights, you're declaring your status. Again, a living man and woman endowed with your rights by your Creator. Now, if you are a statutory obligor, you only have the rights and privileges that the Family Court Act or the UIFSA, Uniform Interstate Family Support Act, gives you in the statute. Okay? And again, every state has them. All right? So I'll let you read this and we'll move on to a conditional acceptance. Again, your agreement pending the presentation of evidence by the plaintiff. Again, the plaintiff or the petitioner has the burden of proof. You don't have to provide any proof. Okay, understand that. This is why you shouldn't answer any questions. All right? And it's okay to say, well, I don't recognize your proof of authority. You must prove it to me. There's nothing wrong with saying you're looking for proof of authority. Do not argue with these people. All you're going to say is that, well, listen, we're only having a discussion. I'm debating you. I wish for you to prove your authority in writing. And here's another thing that happens all the time. And this is why I got to laugh when, there's some clowns out there. Oh, Rick's paperwork doesn't work. There are all of these factors involved. Okay? One, you're dealing with criminals. Two, they just go, yeah, your paperwork's denied. And people accept it. When they say your paperwork is denied, it's really an offer. Okay? Everything's about an offer and acceptance. And by you just walking away saying, oh, they denied my paperwork, they dismissed my paperwork, you're accepting it. Well, you got to say, I don't accept your verbal denial. I want it in writing. Let the record reflect. Or you say, did you receive my paperwork? Did you receive my notifications? Yes or no? If they don't answer, let the record show that the fact finder, and a fact finder is a judge, is a support magistrate, a friend of the court, whatever names they're using in your state, commissioner, judge surrogate, whatever it is. Okay, I don't have a written down list of all of them, but that's what a fact finder is. It's a proceeding, and their job is to find the facts and prove the facts in issue. Okay, so and then you can say, let the record show that I'm not getting a response. Let the record show silence is admission that they cannot respond to the facts presented in my affidavits. Something to that effect. Okay. Again, there's a definition called. Hold on a second. Okay, admission by silence. Black's Black's Law Dictionary, excuse me. The failure of a party to speak after another party's assertion of a fact that, if untrue, would naturally compel a person to deny the statement. So then by them remaining silent means they're admitting. So they're admitting by silence. Okay. Implied admission, an admission reasonably inferred from a party. So this is another thing that you got to avoid, implied admission. So you answering a question could be taken as an implied admission of the court's authority. So that's why you should try to refrain from answering any questions. Okay? So, all right, where'd I leave you? You're informing the court that they bear the burden of proof. Now, you're willing to appear in court as long as the evidence is presented. So you're going to put this in writing. Okay? And again, a non-response or failure to provide proof is just a lack of evidence. It is evidence that the court lacks authority and the matter is stopped by silence. So that means the matter is over. So their failure to provide proof. Now, if they had proof of authority, they should have no problem. Many times they just go, I have jurisdiction. Okay, show me. I'm not saying you don't. I'm just saying, please show me. Again, you don't want to argue with these people. You get nowhere with it. They actually like it when you argue with them, so they can get you out of there quickly. So and I used to do that dumb shit when I first started this. So, and it wasn't until I was polite with the judge. And there's a video, again, if any of you want to see, the first person I got off child support was me. And I have proof of it. So anybody claiming there's no proof, they're so full of shit. This is one idiot out there who I won't even say his name. He's a moron. It's out there. All you gotta do is go back to my earlier videos, scroll through them. You'll see there's a video of me in there. I snuck in my iPhone in my pocket and I videoed the whole thing. And I was very polite. And he was nice to me too. And like a month later, he vacated everything. Okay? So, and I proved it. I didn't plan on it to happen. I was hoping it happened. Just so happened. I just started making videos at that time, and I had proof. Okay. Here's another thing. Now I'm not pushing this. I'm not one of those influencers on TikTok or whatever. This thing is really good. It's called the Plaud, Plaud. Okay, it's a couple $100, but it's worth it. This thing's unbelievable. This thing will transcribe your verbal recording. You can record a phone conversation. You could record in court. You can, if you're driving in your car and you had an idea, you can just verbalize it and it'll transcribe it. It's really good. Now, the reason why I'm saying that is that these courts, they audio record the whole thing, but they also they doctor the transcriptions. Okay, I know because I caught them doing it to me, and I can't tell you how many transcriptions I've seen, and I can literally pick out where they leave out all the words, and it doesn't. What they're doing is they're hiding evidence. They're tampering with evidence technically. So if you bring your own, put it in your pocket, you record, you have proof. Okay. Again, they do this all the time. They're doing this right now, and with the whole Joe Biden thing. I'm not going to get into it. Those of you that follow along with politics, I really don't. I don't watch the news. I don't watch other videos I don't watch child support videos of anybody. I stay to myself. I work, and that's it. So I have no idea what's going on out there in the YouTube or this world or that, whereas as far as, child support videos, I don't know about any of that stuff. Okay, so I don't think I'm going to learn anything. So I try to learn on my own. I buy books. I use certain dictionaries, take notes. And I do a lot of work. Trust me, I work almost every day. 3-4 hours. I don't have anybody working for me, any of that stuff. strictly a one-man operation. Okay? So, again, this is going to be in writing. Now, again, when we get back to the burden of proof thing, who is the actor? The actor is the person bringing the claim to the court, the dispute, filing a petition, an application. Petition application, same shit. Okay, and this is from Bouvier's Law Dictionary, 1839. Actor, a plaintiff or complainant. I added this because back then they didn't recognize women. so I added, or she, on whom the burden of proof lies. In acts of replevin, both parties are said to be actors. The proctor or advocate in the courts of civil law was called actor. Okay, so the actor who brings in the dispute for child support to the state agency is responsible for proving claims with factual evidence. Okay, so almost always the fact finder, the child support administrator, prepares findings of fact or conclusions of law, then recommends an order based on presumptions. Okay, there's rarely any evidence. I remember when I was doing my case, and I fired my lawyers, and I was all on my own. And I remember during the proceeding, I'm like, I'd like to let the record show I wish to introduce evidence. And the court officer was like, she just was going through, she came over and just took them and like pushed them to the side. They don't want any evidence. And I'm trying to remember if I got the transcript of that, but there was no mention of it in the transcript, I'm pretty sure. That's the type of stuff they remove from the transcript. Okay. So, but there's no evidence. It's all based on presumptions, and a presumption is not evidence. Okay? So, if you are the respondent or defendant, you have absolutely no burden of proof. This includes providing your private information, income taxes, wage receipts, etc. Because as a private Christian man, woman, you have the right to privacy. Now, again, if you're Muslim, that's your God. I'm not saying, I'm just going by this country and the Constitution, the Bill of Rights. All of these things were based on the scriptures of the Christian Bible. That's the way they were founded. So it's customary in this country to say that you're a Christian. You don't have to believe it. Just say you are. If it goes against it, just say that you're a private man or woman. Leave the Christian part out. Okay? There's a reason for that. Okay? So again, obligations. The court and its fact finder must provide proof of authority when demanded. We went over this before. Okay? So your notice of reservation of right challenges the presumption and shifts the burden on them. See, what they do is they shift the burden on us because you're accused of everything. And they need you there. This is why they intimidate you. When you show up, you're actually uniting with the other party. It's called joinder. They need that. Okay? And whenever they issue you a default order, it's because it's presumed you are a statutory obligor. So that means you're a party to the case, and then you're a party to your state's Uniform Interstate Family Support Act. And I'll give you a quick example. Okay, in California, their Uniform Interstate Family Support Act, or UIFSA, UIFSA, is under the California Family Code, okay? And here is an obligor's duty of support. So because you're presumed an obligor, you owe a duty of support. But you're not an obligor. You're a living man. You're a living woman, okay? Connecticut, okay? Maryland, and second, Illinois. So these are all New York Family Court Act. Okay, so every state has its own code, act, general statutes, okay, for the Uniform Interstate Family Support Act, and they need the uniformity so they can enforce an order from every state. Okay, so if New York issues an order, it could be enforceable in Connecticut, it could be enforceable in California. That's why they use these things. Okay. Florida statutes. Okay, now, real quickly, all of these courts operate as military tribunals. They don't tell you this. This is like a little shh that you're not supposed to notice, but I'm going to give you a quick example. So, right here in Florida, the state, they refer to the courts as state tribunals. Okay? Right? General provisions, state tribunal. This is New York. State tribunal. Almost every state has this. Okay, so family court is the tribunal of this state. And again, some states it's the in California it's the Superior Court. Pennsylvania it's what the hell are those courts called? Well, let me look here. Connecticut, the Superior Court in Connecticut. Maryland, it's the circuit courts. Okay, so I'll give you an idea. Okay, but again, if you notice, they all say tribunals. So maybe you want to ask why this happened. I'll give you a real quick history. During the Civil War, Lincoln, who is not this great president that history wants you in the movies and all these books out there want you to believe, he was not a good guy. He's the start of what caused the change of the laws in this country. He secretly imposed martial law, okay? And we were considered belligerents at that point, okay? So, let me see if I can find it here. Okay, so here we go. And I'll get back to the Christian thing real quickly. Being a Christian is important because the original Constitution is based on the scriptures of the Bible, making Christians the highest authority. One of the key reasons to declare yourself a Christian is the legal framework under which the courts operate. The courts, in fact, function as military tribunals under Roman law. This means that under Roman law, the courts are bound to follow the customs of the country they have conquered. So yes, we've been conquered by declaring yourself a Christian. We just don't know it. And you are aligning with the highest authority recognized by the courts. Okay, and here's the quick history right here. Okay, you could pause and read it. Okay, so I'm going to start moving along here. I can't stop and read every slide because this video will be who knows how long, an hour. Okay, so what I'll do is just slowly move along. I'll let you guys pause it and you can read it. Okay, but this is really important right here, is declaring your true status. Everything comes down to your status. Okay, all of these things that they're doing to us is based on a presumption of your status. And these courts, they do not have authority over a living soul, a Christian. Okay, they only because again, a statutory artificial person, a statutory obligor, a fiction of law. Okay, they only exist on paper. That means that if you exist on paper, you can't speak, you can't see, you can't hear. That's why they want you quiet when you're in there. So that's the best way to do these things. And it's not because I offer paperwork. If you want to write your own paperwork, go right ahead. I'm just telling you, it's better to put things in writing. Okay, because they will not let you speak. And then if you try and get the transcription, it's going to be edited. I'm just telling you. I've been doing this for a while. Okay, I've been doing this since 2012 with my own, and then been doing this stuff since 2017. Okay, and again, I know a lot more now than I knew then. So please refer to my newer videos, and if something I said in my old videos doesn't jive with this video, trust this video. Okay, this version of me is smarter than that version of me. It's just the natural progression. Okay, so, and I apologize. So again, if a lot of people I tell don't consent, you don't understand what you're consenting to, which is why I would rather you not speak. Because again, if you speak and they could tell right away you don't know what you're saying, they're not going to take you serious. This is why they verbally deny the paperwork, because they cannot answer the paperwork. Okay, so let's move on. You could read this. Okay, there's a little Latin here. Okay, the word person in legal terminology is perceived as a general word which normally includes in its scope a varieties of entities other than human beings. So in other words, when you're a person, they presume you are anything but a human being. Okay, so an entity, you're an obligor. You're a fictitious, artificial person. You're a debtor. An obligor or a debtor is basically the same thing. You're a non-custodial parent. All of those, your offspring is a child defined under the Uniform Interstate Family Support Act of your state. Okay. You're in New York, I could give you, New York, you're considered an adult at age 18. 16. But not with child support. Child support you're supposed to pay up until 22 years old if they're going to college. Why? Because it benefits the state. Okay? So, again, by declaring and defining your true status, you rebut the presumptions of your false status and the legal and statutory obligations applied. Again, now if you're an obligor, you have statutory obligations you're supposed to meet. And if you're not meeting them, they're allowed to retroactively charge you with it. Okay? And again, this is some stuff here I was talking about before. Again, pause and read it. Okay? The United States, 50 states, and their agencies are corporations with DUN numbers. I provide an email with my paperwork with DUNS numbers. It's the very last email you get. Okay, so what that means is that they're corporations. And I've touched on this in past videos. So just pause and read this. Now, this is a huge mistake I see all the time. And it's these people, they play on your moral fabric that you want to have custody of your children. So what happens is there are plenty of men out there that the mother or the father, women also, I get emails from women as well, that they're not letting you see your child. So you go to the court, and sometimes people go to court when they don't even have a child support order. Okay, they just want to see their offspring. And they file a petition. What? This is a huge mistake. I can't tell you how many people I've seen be screwed over because of that. They go to court, they file a petition for custody, and really what you're doing is you're authorizing the court to act on your behalf. Also, you're admitting to all of these statutory statuses that I'm talking about, and you're done. You're done. I can't tell you how many times I've seen that. I don't know what to tell you if you're not getting to see your child. Okay? All I'm telling you, if you don't want to pay child support through the system, then don't go to court asking for help with custody. I'm just telling you. because these are all statutory courts. Nothing good is going to come from you going there. Okay, what you're doing is you're inviting the vampire into your home. Really, that's what these courts are. They're vampires. Okay, so please stay out. If you don't mind paying child support, then go there if you want to get custody. Okay, or you try and work out a deal with the mother. And you know, that's all I could tell you. All right, so 35 minutes, Jesus Christ. I'm sorry. Now, if you get a summons, in many states, California, Florida, Michigan, they use nom de gores, which is when your name is spelled in all capital letters. Now, that's not you. Okay, that's what's called a misnomer. Okay, a misnomer is a mistake in naming a person, place, or thing on a legal instrument. So right there, it's a false identity. Now again, driver's licenses, bills, your name is in all capital. That's because that's not you. Okay, I could do another video on traffic tickets, how when you apply for a public benefit or any benefit from a corporation, like you go to, Walmart, Target, Home Depot. As soon as you walk in there, you become a customer because you're walking in there and if you buy a product, you become a customer. When you get a driver's license, you become a driver. When you go into a hospital, you become a patient. When you get an insurance policy, you become the insured. Okay, see how that works? And when you go to child support court, you become the obligor. Okay? That's how they get around these things. So whenever you see on their paperwork, like say you get a ticket, driver was speeding, was clocked. I forgot the verbiage. I should know it. I used to do it. But anyway, that's how they get you. Okay. So again, you can file paperwork to claim a mistake of fact. Okay. Again, this is coercive threats. I was talking about this earlier. In New York, coercive threats look like this. This is word for word. Notice, your failure to appear in person or virtually may result in suspension of your driving privileges. State issued, professional, occupational, Further, your failure to appear will result in the entry of an order of default unless service has been made by mail. Did you see that? So those of you in New York, if they did not serve you, and by somebody coming to your home, serving you with a summons or a notice to appear, if you received it in mail and you haven't been to court yet, that is a defense. Okay? So they cannot file a default against you. That's what happened to me. Okay? Real fast. If anybody's still with me at 38 minutes, special appearance only applies when you're going to court the first time. If you've been to court already, you cannot file a special appearance. Okay? You can't file a special appearance 5 years later. Okay? So, all right, so here's some definitions. More definitions, understand different types of obligations. So we're moving along here. Okay, definitions for you guys. Definitions of consent. Now, in all of their laws and stuff, they always use the word party or parties. Here's what a party is. One who takes part in a transaction. A party to a contract. Okay? Did you see that? Party to a contract. You do not have to consent to be a party to a contract. Okay? I am not and in my paperwork I include that. Okay. Participation, you have to take part in something. This is why a lot of times you are ordered to participate. They cannot order you to participate. But again, they're acting from, and if you follow their order, you're implying they have authority over you. This is why you should always challenge with paperwork. Okay, again, I covered the moral natural obligation, party. Okay, moving along. Moving along. Here's another way to get implied consent. Using court forms. They do this all the time. You got to fill out this form. You're allowed to file an affidavit. I choose to file an affidavit. Okay. Let me see if I have that. Affidavit is a voluntary declaration of facts written down and sworn to by the declarant, which is you, before an officer, notary, or these support magistrates, or judges, whoever. Okay. And here's another thing. I have not seen any statutory power of these people that they can verbally deny things. Their powers come from the statute that they're operating under. But again, you do not have to, I don't accept your denial. I want it in writing. Here's the thing, it doesn't exist. Once they don't have the power to make law by voice, but verbally, excuse me. Okay, so read this. I gotta move along, 40 minutes is crazy. That's what happens when I don't make a video in a long time. Okay, agency needs your consent. Read this. Principal. So the petitioner is the principal. The agent or the agency is it's called a principal and agent case. Okay, when you show up, you become a party to this transaction. Okay, you become a principal party. Okay. And that's it. And again, I'm sorry, I'm rusty. And just trust me, I've been working. And hopefully it doesn't take me so long to make a video. Again, if you want to reach out to me, if you're still here, 40 minutes later, I noticed that a lot of people don't have the patience or the time. But again, I'm trying to get back into this stuff. All right. And I'll talk to you guys soon. Bye.